Thank you all for tuning into this video for the start of our In Conversation With series. My name is Anne Rose, and I'm Associate and Co-Lead of the Blockchain Group at Mischon de Reya. I'm also founder of Tech London Advocates Blockchain Legal and Regulatory Group. To kick off this series, I am delighted to be joined by Professor Sarah Green, the Commissioner for Commercial and Common Law at the Law Commission of England and Wales. Professor Green read law and then industrial relations at Oxford University in the late 1990s before working in the IT industry during the dot-com boom of the early 2000s at Accenture, and then moving into academia, Birmingham, Oxford, and most recently, Bristol universities. So Sarah, thank you so much for joining me here today. As many people watching this video will be aware, the Law Commission has a number of projects on the go which touch on blockchain technology. These include smart contracts and what the law needs to do to facilitate them, digitized documents and what the law needs to do to facilitate the use of them as opposed to paper documents, and then another one on digitized assets more generally. So, for example, tokens on a blockchain and virtual currencies. So could you please talk through these projects a little more and explain why these are important and what you hope to achieve?
Yes, thank you, Anne. As you say, we're looking at lots of emerging tech issues at the Law Commission at the moment. It's a hugely exciting time to be in law reform. So I feel very lucky to have come across this job at this point in time. So current projects are concerned with, first, as you say, smart contracts. And that sounds very broad. And at the moment it is, and it's deliberately so. So there's a call for evidence out at the moment, and that's available on the Law Commission website. And the purpose of a call for evidence is, as the name suggests, what we're trying to do at the Law Commission is essentially make sure that the law of contract can accommodate the sorts of smart contracts that parties want to use. Now, we're sort of fairly confident that the tools and devices that the law of contract has are perfectly capable of accommodating smart contracts. But of course, they are bound to need tweaks, they are bound to need modifications. And basically, we just want to know that from the people who are using these smart contracts. So the call for evidence is to elicit responses from parties who are using this technology in this way, to find out if there are any blockers that they've encountered, or if there's anything that the law could do better to facilitate the use of these contracts, so that we can then process those responses and suggest any necessary reforms to the law of contract that might be necessary. So that's the stage we're at the moment. We're building on the work that the UKJT, so the UK Jurisdiction Task Force did with their statement that they released the year before last now. So we're taking the material and the conclusions in that, and we're working on what to do next, basically, in relation to smart contracts. So the call for evidence, as I said, is live at the moment, and that will finish in terms of inviting responses at the end of this month. So if anybody's listening and they're interested, please do tell us what you think. And then, as I said, we'll look at those responses and think of what we need to do to accommodate those. The other project that we are engaged in, as you said, is electronic documents. Now, this one is, the thing about smart contracts is it's more speculative. One of the things that we're concerned with smart contracts is ensuring that in the future, smart contracts are easier to use. Electronic documents is a bit different, really. I think it's a more pressing, it's a more urgent need, because at the moment, commercial parties are wanting to use electronic documents, I should say, and they want them to have the same effect as paper documents. But basically, the way the law operates at the moment, they don't. So you can use a paper document, it can have a certain effect, but if you want to use an electronic version, as parties are now bound to do, it won't at the moment have that same effect. So our project is looking at how to accommodate that, or accommodate those documents, and to ensure that they do have an analogous effect to paper documents. And this is of huge importance importance to international trade at the moment. We'll be releasing a consultation paper on that in the next month. And again, the way the Law Commission works is it's a very consultative process. And we invite responses on our proposals from anybody who might be interested, whether they use them, whether they study them. We want to hear from anybody who has a view on our proposals, which we then review and submit to government. And then the third one that you mentioned is on digital assets more broadly, which we're just at the beginning of this project, really. And again, that sounds very broad, but I think it needs to be, because that project is concerned with how to ensure that digitized assets or crypto assets, there is quite a lot of toing and froing about definitions, which in itself is quite a difficult thing to establish clearly. But basically, as you said, things like tokens on a blockchain, virtual currencies, dematerialized forms of conventional tangible assets, we want to make sure, again, that the law is able to accommodate these and is able to ensure integrity of transactions with these things, so that parties can be certain that if they engage in transactions using these sorts of assets, that they will get the legal protection and the legal support that they legitimately expect. So that is going to take the form of a call for evidence fairly shortly at the start of the summer, and that will lead on to a consultation paper after that.
Brilliant. Well, lots going on. Fantastic. So we've talked a little bit about changes that may need to be made to ensure the law is fit for purpose and does what it's supposed to do. But what about the changes to the role of the traditional lawyer more generally? So historically, I think lawyers have been at their most effective and socially useful when they've operated as transactional engineers that facilitate these new forms of business and other social relationships. Take, for example, the development and growth of Silicon Valley as a center for digital technologies in the early 1970s. And while the idea of the clustering of similar businesses was a significant source of innovation, there is a broad consensus that the legal industry was also important in the development of technology firms and facilitating that innovation. So, for example, lawyers are responsible for drafting the innovative contractual provisions that protected high-risk investors, for instance, angel investors and venture capitalists, from the relational and performance risks associated with investing in young companies. So how do you see the role of lawyers changing with the adoption of blockchain technology, if at all?
Well, I think it's a hugely exciting time to be a lawyer, especially a young lawyer just coming into the profession. I mean, back in the dark ages, when I was doing my law degree, we were always encouraged to study European languages and told that that's what would make us marketable, because obviously then we would be able to work across jurisdictions. And I think now, one of the ways that young lawyers or people entering the profession can do that is to familiarize themselves with code. Not necessarily being able to code and build a website from scratch, but at least have some idea of the logical architecture of code.
I agree, almost like pseudocode. So not necessarily having to know Python and Swift, as much as I love them and I love learning programming languages, but actually just thinking more in Boolean language, if X, then Y.
Yeah, exactly. And just to have those logical thought processes, or sort of machine logical thought processes, as opposed to human logical thought processes, because obviously they're quite different. And I think if you don't get that, and you want to be the sort of lawyer who is involved in anything related to code, in anything relating to emerging tech, then you'll probably struggle. So I think that's an exciting opportunity. And I think it's also something actually that universities, some have already picked up on it, but I'm surprised at how few have actually. I would have imagined that more universities and educational institutions would have put some form of coding modules into their courses. So I think,
I agree. Actually,
yeah.
I'm currently trying to design one at our firm as well.
Oh, okay. Well, I mean, it is difficult. Of course, it is difficult to know exactly what to put in there, but I think it's definitely something that is worth the candle, because it can transform your ability as a lawyer, just to have that extra dimension of understanding. I think it's also worth saying, so I talk to quite a lot of students, and I think it's also worth saying that it's not necessary to do that. I don't think that a lot of my colleagues used to say that the robots are going to take over the world. I don't think that emerging tech is going to displace the traditional lawyer. I really don't. I just think it's opening up a new avenue for those people who are interested in it. And as I said, I think it's a very exciting avenue to go down, but I don't think it's necessary. I think the point is that if you want to do that, that you probably should get yourself a grounding in code and code logic. And also, I think what's even more important is the ability to think non-incrementally about law. Because I think one of the things with the emerging tech we're seeing now, and particularly with distributed ledger, is that it's not, and obviously, since I've been in this position of thinking about how to reform the law, I think sometimes the key is that it's easier to start again from first principles and say, this is day zero. So what do we do with the law to ensure that it will work for a smart contract or for a tokenized asset on a blockchain? Maybe incremental development of current law is the way to go, and that could sometimes be the case. But I think lawyers now need to have the audacity, really, sometimes to think, well, maybe it's not about that. Maybe it's about, if we were given some carte blanche, what would we do in terms of legal rules to accommodate these new technologies? So I think it's those two things, really. So I suppose, in short, I would say I don't think the traditional lawyer is going to be displaced at all. But I think the opportunities that are opening up for those lawyers who have an interest or an inclination towards emerging tech are going to increase in volume and in availability.
Amazing. And so I understand in the past you attended a coding bootcamp in Chicago, and you're involved in the construction of websites for Sony PlayStation 2. So do you think that experience impacted your legal interests? And do you think it's important for lawyers to be kind of exploring that as well? You've just touched on a little bit of that.
Yeah, I mean, that made a big difference. I don't think I would have been interested at all if I hadn't done that. So you are making me feel really old, because I just realized that was, I was working on the Sony PlayStation, the first B2C website. So it was a new thing, selling things to customers over the internet. So we were working on putting that website together. And as you say, it was in the dot-com boom. So again, a really exciting time to be involved in that. And I think if I hadn't had that coding background, then when smart contracts started to come onto the legal scene and come within lawyers' awareness, I probably wouldn't have picked up on them or been interested in them, or really been able to see, I think, what the potential issues might be. So everything that I've just said about machine logic being different to human logic, it's not obvious, I don't think, to anyone who's never done coding. So it was years ago, I first heard of smart contracts when I was still doing research in contract law. And none of my colleagues was particularly interested in smart contracts. They weren't really on their radar. But I started thinking then, this could blow the whole thing open. If what we're trying to do is interpret machine code rather than interpret human language, which, as you know, is difficult enough as it is, even with two beings who supposedly speak the same language. I started thinking, what on earth are we going to do once we have another interpretative layer, which is the machine code? So I think, well, no, in fact, I know that my early experience as a coder was really then what led to my interest as an academic, and what made me think about these issues in a way that I'm absolutely certain I wouldn't otherwise have done. Because, as I said, a lot of the people that I worked with at the time just didn't really notice them come along, didn't really find them interesting. And I can understand why you wouldn't find them interesting if you didn't have that grounding. So yeah, I feel again very fortunate that those things came together and presented me with the opportunities they did, really.
It's really interesting you talk about that, and talk about, how you experienced smart contracts or self-executing agreements quite a long time ago. So when does the Law Commission actually take a view that a consultation needs to take place? So by this, I mean, how long does, say, a novel digital technology or something similar have to be around for before the Law Commission takes a decision as to whether reform should take place, or they should do a call for evidence, or further guidance should be released? And yeah, how does it all work?
Well, there are several ways that the Law Commission's projects get off the ground. But really, the important thing is that the Law Commission is an independent arm's length body. So for anybody who's watching this who's not clear about that, we're not a government department. We are an independent body, arm's length from government. And we get ministerial references. That's one of the ways in which we get our work. But the important thing to note is that we don't take anything forward unless government has expressed a serious intention to consider it. So at the end of some of our projects, not all of them, we come up with a draft bill, we come up with proposed legislation, which we then present to government. And then, of course, it's up to government whether to take that further or not. So we do not get the go-ahead on projects unless government has a serious intention. So I suppose the short answer to your question is it's when government feels that it has that serious intention and feels that the time is right in terms of a priority of resources. I mean, it's not just that, obviously. We need to bring these projects and these issues to government's attention. Sometimes they do that by themselves. Other times it will be more internal to the Law Commission and presenting that. We also invite, I mean, the whole thing's really consultative. So we also invite anybody to suggest programs for reform. Every few years we have a program for reform. The 14th one is coming up in the next year. We're in the process now of inviting anyone, and I do mean anyone, to say, we have experienced problems with this area of law. It's no longer fit for purpose. Maybe it never was. Maybe it just hasn't kept up with social developments or technological developments. So that's another way that it happens. Anybody can say, when we put out that paper and say, look, tell us what we need to look at, anybody can do that. So sometimes it will come that way. So I suppose it's a sort of critical mass, when enough people and enough users, for want of a better word, come to the conclusion that, look, this law just doesn't work anymore, and it doesn't do what we want it to do, and it doesn't protect our expectations. It has to be a perfect storm, really, I suppose. That there has to be that sort of groundswell. Government has to agree, and then we get the go ahead.
Very interesting, thank you. So yeah, and you mentioned that your call for evidence for smart contracts came about following the UK Jurisdictional Task Force statement on crypto assets and smart contracts back in November 2019. And it's currently consulting at the moment as well on a possible new arbitration procedure aimed at facilitating the rapid, informal and cost-effective resolution of disputes arising out of novel technologies, including digital assets, smart contracts, blockchain and fintech. And I've had the pleasure of being part of this drafting group for this, which has been a really fantastic experience. So what is the Law Commission's view on how the law needs to change following that publication of the first legal statement? While the statement makes it clear it's possible to have a property right in a crypto asset, does the Law Commission think you can have a possessory right in a crypto asset or a token under English law?
So, I mean, that's the big question. That's the really interesting question. And that's what a lot of my work was concerned with before I joined the Law Commission. So I very much have my personal views as an academic. As the Law Commission at the moment, because as I said to you at the very beginning of that project, so there is no official Law Commission view yet because we are working through all the questions. You're absolutely right. We agree with the UKJT statement that you can have property rights in these things. But of course, the big question for most of these transactions and most of these uses is, can you also have a possessory right? So can you have the same protections of your property rights as you can in conventional tangible assets. So really, that's what we're trying to establish at the moment. And to take, I suppose, the electronic documents piece, which is further along, and that also looks at possession, because of course what's important is if you can possess an electronic document, then it's more likely to have the same effect as a paper document. What we did there was to look at what's legally relevant about possession. And the aim of that really was to decouple the two notions of tangibility and possession, because as the common law has grown up, those two things have become, I think, elided. So it didn't really matter for ages. So until the digital age, everything you wanted to possess was probably tangible anyway. So there was never any question about what was it that made this thing have these legal functions. It was tangible and you could possess it. So the question never arose. But of course, in the digital age, a lot of the assets that we've already talked about today are regarded by many as intangible. Now, whether or not you agree with that as a conclusion, I personally probably don't actually, but I also don't think it matters, because I don't think that tangibility is necessarily the touchstone of what can be possessed. So the way that we're approaching it at the Law Commission, and as I said, this is not the final conclusion, and this is not the Law Commission position because it hasn't been reached yet. But what we are doing is looking at what is important about amenability to possession and seeing how that applies to various different assets, and asking the question really, is intangibility at all important in that, or is it a red herring?
It's very interesting. I mean, I suppose kind of touching on that, I heard you say in a previous interview, what crypto assets will do for jurisdictions is equivalent to what streaming did for record shops. So record shops are still around and they're still a really valuable part of the shopping culture, which record enthusiasts still want to use, but they're not the everyday one-stop shop for music. People go on to Spotify and Apple Music. So could you talk a little bit more about this analogy, please?
Yeah, I mean, I think that that feeds into what I was saying about lawyers. I think there's a lot of fear in certain quarters about the world changing and becoming unrecognizable, and I think that's a misplaced fear. So I think the thing with crypto assets and with digital assets more generally is, again, that they provide this whole new avenue, but they don't shut off the old avenues. I mean, of course, we're still going to be dealing with tangible conventional assets, and of course, we're still going to be interested in those. And I mean, the record shop analogy was really because I was thinking that when streaming services first came online, I think record shops really did suffer. There's the real attraction of the new. But now, I mean, certainly in Bristol and London and the places that when I'm allowed out, I go to, is that I see more and more of those. And, they tend to be really busy. Again, when people are allowed into them, obviously not at the moment, but I think they are re-emerging, and people are realizing again and remembering, the value of tangible music and the lovely way that vinyl records look and the way that they, the way that they sound and the way that they smell. And, I don't think there needs to be a fear of losing that. It's just that isn't the single paradigm anymore of how we own things and how we deal with things, and that there's just this other avenue which is there now, and it's open to those people who are interested in it.
Thank you, Sarah. I'm afraid we're going to have to bring our session to an end today. I've thoroughly enjoyed having you as a guest on our In Conversation With series. Joining us for the next video is Al Palermo from Jur. We should be discussing Jur and its mission to solve the problem of access to justice, the Law Tech UK SME platform, blockchain, and the need for effective law and regulation to underpin it.